because searching rejected petitions so rejected petitions search. So I put this petition that got rejected, stop the World Health Organization from attempting to override our rights. Not showing up. Nothing there, look. But yet it got rejected, so it shouldn't be under rejected petitions. Don't you think that's strange? See if it's gone live. It's not even showing up. Try all petitions. Nothing there, not even under rejected petitions. So what is happening with that? So I made a Freedom of Information request to the Petitions Committee, and it was, what legislation are you actually even operating this committee on? Because I don't think there is any other than the underlying right to petition enactment. I mean, there are many local government acts petitioning for local government referendums, procedures, election procedures. And I'm like, I said to them, look, so, you got all these standards, right? All these policies. I don't want to know what your policies or standards are. What legislation of the government enactment of law is this Petitions Committee operating under, other than the right to petition under the 1688 bill? And I haven't heard back from them. Now, where is the petition? It's not even showing up rejected. So we won't even let people know that I submitted it, and with that evidence of the 1700 enactment. Now, I've already taken a screenshot of this earlier. If you put 15-minute city, so there are only 5 results here. Stop the implementation of 15-minute cities across the UK. Well, the government can do that. It can bring in legislation to stop them. Enable a freedom of movement forbidding the use of 15-minute cities in England. Well, you could do that as well. Discuss stopping 15-minute cities. A government to remove the power of local authorities to set up 15-minute cities. Well, you can do that as well. In fact, central government would be the place to go to do that if you wanted to do it for all England, not a local council, because that is only for that area. You could even have legislation in effect whereby if any local council in England and the whole of England wanted to have a 15-minute city, they would have to seek the approval of the electorate, a certain percentage. They would have to have, unless they can get a certain approval, because it's quite a big dramatic thing changing that. Having a 15-minute city and restricting movement around the whole city is so quite serious change that why wouldn't you, we've got to seek approval from the people for this. In fact, for a lot of things, why don't the council have to seek approval for any major change like that first, rather than, propose it, then have a consultation? Because the consultation doesn't have to be actually that doesn't have to be acted on, the consultation. This is different. We're talking about before, get approval before they can even start paying for them to build the models and, get the architects in to start spending loads of money on even planning it out, So these petitions here, these can all be acted. The government can do all these, and you wouldn't even have to say how you wanted it done. When you ask the government for something, like I say, it's like going into a pizza shop and saying, right, I want a mushroom and tomato margarita with anchovies, right? I don't make the pizza. I tell them what pizza I want, right? Now they're saying you can't have that, it's not on the menu. Well, because this is like 50-minute cities, a government thing. It's government, it's governance. Remember, it was local or national governance. It's national governance when you're wanting to change the law for all of England that all councils will comply with. It's almost like saying you can't petition about changing the Local Governments Act or something like that. Go see the local government. The local government doesn't create the Local Government Act. So these rejected petitions, 1, 2, 3, 4. There is no climate crisis or emergency. So there's 4, not that top one. There's 1, 2, 3, 4, 1, 2, 3, 4. There's 4 petitions here that were rejected, could have run. And I believe the Parliament Petitions Committee don't want those petitions to run because they don't want people to sign them because they don't want to have to debate it or actually, in fact, stop the 50-minute cities. So right there, that's a censorship of... That's censoring the case that you're bringing, censoring free speech, and it's not even debating it. I mean, they didn't want to put it live to see how many people support it or back it. And what process or procedure would they go about implementing that? Well, that's not our problem. That's what they have to decide. We say that we want it. We make the order, and then they fulfil the order. That's what Sunak's all about. Deliver. We'd have to work out how they're going to implement it into the law. That's their problem. We say what we want, and then they make up the recipe for it. So they're just pretending that they don't know how to do it or it can't be done, which is... So these 4 petitions could also... All 4 of those could run separately and get signatures, and then they would have to be amalgamated together. That is really a legitimate process by the 2011 Local Government Act amalgamation for petitions, but there's nothing to say that can't be used for central government. In fact, in the government, in the Local Authorities Act, it clearly states if you're using the right to petition that you don't have to comply with the clauses, and you can even make up your own provisions and so forth if you want. But you'd be lucky making up your own provisions to Parliament Petitions Committee because you only got 500 characters or 50 words or 500 characters or whatever. It's not much, not many characters, not many words, not many at all. And you can put. I don't know why they let you put links. I don't know why they've made it so you can have a link on there because they always say, it's linked to frivolous or false information. But it's legislation. It's English legislation on the local government. It's their data on their website. I put my own website. Oh no, you can't put your link. It's not. It's legitimate, false or fraudulent information. No, it's not. I'm trying the information to the public. It's almost like, how do you prove anything in court? By evidence and see what people think to whether it is true or not. It's almost like censoring witness. It's like censoring witness statements in court. You give the statement and then they decide whether they think you're telling the truth or not. You don't stop you from saying it. You say it, and then they've got to decide whether they think you're lying or telling the truth. You're under oath, or whether they think you're right or wrong. It's almost like, it's almost kind of like they don't want there to be a case. They don't want there to be proceedings. They don't want there to be a trial. It's almost like looking at all the evidence and then the judge just saying, not having a hearing or trial. The trial's there to hear. They don't want people to hear or see this. That's a problem. And that's why I believe that it's a perversion of the course of justice. And the word justice is due legal process, lawful process, rightful process, and this is legal proceedings. It is legal proceedings when you want to stop the World Health Organization from taking over our rights. That Teslari petition is on here somewhere. I don't know what's happened to mine. It's not even on the rejected list, so I don't know where it's disappeared to. I don't know what they're playing at, really. And they haven't answered my freedom of information request yet. So this is evidence here. These have been unlawfully censored, rejected. It's a perversion. This is perverting the course of justice, and it's also unlawful censorship. You see, in that video that I put with that American girl, that counsellor cannot censor her speech. if he does, then he will be perverting the course of justice. In America, under the First Amendment, and it's essentially based on ours. They can't censor that statement or speech. She was even swearing in there. So all the standards, Petition Committee standards, is a load of rubbish. They're just wanting to try and keep their own image, or respectful image or whatever. But there isn't a respectful image when you're in criminal proceedings in a magistrate's court. That's the whole point of being charged. You're not legit. Well, so, it's almost like, we don't want to, look on the court listings. John Briggs charged of, robbery, crime, theft. It's all criminals. It's all, rum lot. That's the point. It's almost like saying, it's like Gail Bradbrook, Isleworth Crown Court, whatever, at 3 o'clock, it's almost like they don't want these things to be listed. But Lister, I won't mind, but they're even claiming that, you can't accuse any wrongdoings against the ministers. Yet clearly you can petition for legal cases as well. The Appeal at Jurisdiction Act is only appealing existing cases that have already had a decision made. You can appeal to the House of Lords. You can't remove the judicial function of the House of Lords anyway. It's impossible, not by repealing the Appeal at Jurisdiction Act anyway, because they didn't need that act in the first place. You didn't need any of those Appeal at Jurisdiction Acts to petition any case on any matter to the King or either House of Parliament. If the Commons doesn't have a judicial function anymore, the Lords have got the judicial authority and the persons in there. You can't really take away the right to petition on any subject or matter, because you've got the right of the subjects, which is all the different any topic that you want. So that Appeal at Jurisdiction Act, there was a multiple Appeal at Jurisdiction Acts. Gordon Brown, he can't do it. It's just like, it's not really something that you can do. It's not really a legitimate thing that he's done. This is not a legitimate thing that they've done here by rejecting these. And the thing when they're always rejecting petitions multiple, the thing is, every person who petitions about a different subject, if you just get other people to sign your evidence, you're not letting them attach or bring any more facts or evidence. All they're doing is putting their signature and agreeing with what you wrote. You can't even add comments. The thing when there's multiple petitions like this on the same subject, each one has got a different writ, a different evidence, additional evidence, and that's why they're really supposed to be amalgamated together, like in the Local Government Act. Otherwise, they're getting an odd, and this, like, if it's rejected, it's actually saying that, we're not taking it into consideration. Now, if they're rejecting these, but one of them runs and collects all the signatures, are all the other rejected ones on the same subject going to be taken into account in the debate and the evidence read and, taken on board? Was it rejected because there's already a petition on that? But does that mean that it's rejected and I'm not going to hear the evidence or accept the evidence or read it, or with the one that was accepted at all? The thing with these sort of cases is that they're open to the public. So, you're meant to be, this is meant to be a public inquiry. The basis of a public inquiry, I know, like, it's a special function that is funded by the government on behalf of the public, but the ideology behind the public inquiry is the public are making an inquiry. How public inquiries happen now is the government are setting up special proceedings to make an inquiry on behalf of the public for them. But the whole ideology behind the public inquiry is that the public are going to inquire into matters themselves, which is really what you do when you have a petition and everyone's signing it, but everyone can attach their own comment or statement or any fact, evidence, legislation which is relevant and so forth. For debate or public inquiry, although you can have a petition for a public inquiry, because if it appears to a minister that there is sufficient public demand for one, or enough lone evidence to merit such an inquiry, then you can have one, But this, I really want the Lord Chief Justice to do something to these ministers in the Petitions Committee. I think this is perverting the course of justice, and I don't think it's sufficient. I don't think it's parliamentary ombudsman, because you only go to the ombudsman if nothing happens about a complaint. I mean, it's privileges committee, really. If you've got a complaint against a minister, there is no complaints process for the Petitions Committee because it's you're complaining about the person who is the person themselves or the chair of the committee. So it's either it's privileges committee really if you consider it's a wrongdoing or something wrong criminally, which I think it's perverting the constitution. I think this is censorship, like in the American video that I just put. I think this is censorship of because they're lying. The government can make changes to legislation and local government acts and so forth to make it like a requirement for them to. Very difficult to do anything without public consent unless it's just standard maintenance, standard daily maintenance, sweeping the streets, keeping the roads clean. All these, the way they're doing it currently with public consultations is a lot of rubbish because they're just basically proposing whatever they want, and then they just, we'll ask the public what they think, but then they don't have to go by that. And then we're paying for it all. And a lot of it is really upsetting people and annoying them and taking forever. I think that the law should be that for very big projects like, fitting cycle lanes, changing the whole area of a town, they need to get a consent from 50% of the ward. If 50% of the ward, 51% of the ward do not consent to that, then they can't do it, and they can't even get an architect to even draw up a plan for it and use money to do that unless say, right, we want cycle lanes, can we get consent to proceed with drawings and architects and models? And then they say, no, actually, no, we're all right, we don't want the cycle lanes, we don't want 15-minute cities, we don't want a jet engine factory ruining the Ponyfield. Thank you very much. That is really how it should be working. Not these council chambers are all corporate now, but they wouldn't get, these corporate companies wouldn't be allowed to build anything. And this is the thing, the world, the country is meant to run on what the people vote for and want, not on who's got the most money and who can propose the most. Elon Musk has got, billions, so he could just build factories all day just because he can afford it. All right, if he can afford it. But the thing is, then he will be dictating and shaping the world around us, and that's depressing for a lot of people. This is the thing. I want some action on this because this is crime. This is crime right here. This is censorship. And it is perverting the course of justice of a duly lawful process by using the word standards, basically, effectively, just so they can, it's as an excuse to reject it. There's no standard. You can't have a standard in something that you want the government to do. You decide what you want. And most of these got 5 signatures anyway. There's no such word. They're misusing the word. They're using that word to try and as a big net to catch things they don't want to publish when it's not for that purpose. Standards are meant to be punctuation, spelling, and so forth. There might be some petitions which are kind of a bit silly or ridiculous, but not these ones. They're abusing the procedure. These 4 petitions about 15-minute cities has nothing to do with standards. It's to do with the fact that they don't want to publish it and they don't want people to sign it because they probably would have got 100,000 signatures and they would have had to debate it, and then they might have even had to change the law in it, which they don't want to do. So that's what it's about, and that is a perversion of the course of justice, of due legal process, and it is censorship as well. In fact, it is in breach of the Town and Country Planning Act. These petitions here. This is a published petition. This is Class F on a illuminated device. This is a Class F advertisement on a digitally illuminated device through use of the enactment, and it's required to be published. This is like the newspaper refusing to publish it, or 38 Degrees taking petitions down, which I am pulling 38 Degrees upon that. I want to take them to a small claims court, actually, because I printed some postcards out, and then they took my petition down, so the postcards are advertising it and completely useless because the link doesn't work that I've printed on them. So I wasted £200 getting these really ornate, gold embossed postcards printed. So 38 Degrees is the same as Parliament Petitions Committee. Really, 38 degrees as well, but obviously that's not Judicial Conduct Investigations Office because they're just normal citizens working at 38 degrees. But it should be something should be done about that through the Petitions Committee. Really. Well, actually, it's a perversion. I think 38 degrees are perverting the course of justice as citizens, and these people in the Petitions Committee are elected ministers who are perverting the course of justice, and they can be judged. You can have, like Boris Johnson, they can have legal action against them of a Privileges Committee, and it's a judicial. This is a lot. This is this is like, Lord of the Rolls. This is like 3 magistrates or a grand jury. This petition procedure is legal proceedings to the Palace of Westminster. Therefore, it is a judicial process, and the Judicial Office investigation is responsible for a perversion of course of justice of this man. Some people are trying to stop the World Health Organization from actually taking our rights away and overriding them. And I've indicated that this 1700 Act of Settlement, the final paragraph, prevents them from doing that. And I want that attached to Tess Lowry's petition. So, and her petitions probably awaiting not debated in Parliament. Awaiting government response. Awaiting a debate. Debated, not debated. Oh, here it is. Waiting for 123 days, 116,000 signatures. This is it. It's not got Tess Lowry's name on there, though. This is her petition, though. So this is it. What Tess Lowry... You see, Dr. Tess Lowry has got to make good use of language here. This is all you get. That's all you can write in there. And she hasn't even put any links. She probably could have put a link to a legitimate source and they probably wouldn't have rejected it, or even a government website. But this is what, she's got to write. That's all you get. I think when you're looking at things like this, I mean, it's not even for the fact of what is going to happen to us if we don't intervene in this United Nations action, then it's so serious that you want to be able to add more than Tess Lowry's will have made here. She's like used the highest level standard of English language that you can use, crammed into 3 paragraphs there, because that's all she's got. But otherwise, I mean, I wanted to attach that 1700 Act of Settlement because it just says that the MPs can't not do anything. And the WHO didn't have, the World Health Organization Association didn't have an option to decide whether they, in the first place, when they drafted all their articles and documents and provisions, they didn't have a choice of what they could or could not include. They had to include that, so it wasn't optional in the first place. For that reason of the final part of the 1700 Act of Settlement, because they can't not have it in there, basically. Or if our MPs didn't do anything, well, it just can't. Even if the World Health Organization took that out of there, it would we'd still got the rights. They can't be taken away by a foreign organization, regardless of whether we're a member or not. But I don't know what's happened to my petition. It's not even showing up now as where is it? Hey, this is one of my rejected petitions here. Help further the overriding objective for rights claims that you are party to. Help further the overriding objective for rights claims that you are a party to. Oh, yeah. So basically that means that, it means that, when YouTube take your videos down, if there are a petition advert or for a petition to the government, then the government are a party. They are basically, when you're petitioning the local council for something, they're a party. It basically means that it's like the overriding objective of the criminal procedure rules, right? The who is a party to those proceedings. The court are a party. The Crown Prosecution Service are a party. Your solicitor is a party. You are a party. If you've got a Med 3 form like me, your doctor is a party. If you're using and claiming it, he's a party as well. So like those overriding objectives, when you exercise your rights through the overriding objectives, all parties have to recognise those rights and with their implementation. So that means that, your doctor, if you're ill and your doctor gives you a Med 3, if it means that if the magistrate has to check its legitimacy, then the doctor is party to it because he issued it and you're claiming it, and he's got he's government anyway. It's NHS, isn't it? He's got to, he's got to act, basically respond when required. It means that if you're claiming a right and that right's legitimate, the CPS are meant to recognise it and even apply it. If that right says they can or can't do anything, they're meant to comply with it. In many instances with Extinction Rebellion, the CPS prefer to not acknowledge the rights or ignore them. It helps them because then they don't have to do it. If they, many people don't actually openly voice their claim in them. I did in my proceedings. Extinction Rebellion don't do it that way. They don't seem to want to claim it as a right. Like they like using a defence, which is different, not to be construed as a defence against a charge, is a rights claim. But so yeah, this is all about helping us with YouTube videos, or anything tax. Claiming tax. If I'm petitioning the government and I get a lot of flyers printed and I want to claim the tax back, well, the Petitions Committee are the party that I'm petitioning, and also it's the government anyway. So I want if I want to claim the tax back for that, there's a certain you're not petitioning the farmer or this is the thing. They don't even have a proper procedure for claiming tax back on petition, yet it clearly states that it's exempt. Political parties selling material to raise funds and even the purchase of things, so there's no procedure that they're providing. This is like very primary school, but yet you've got Tess Lowry writing a very, academic petition, cramming it into 3 sentences, and getting over 116,000 signatures. Yet the whole thing has a very, it's almost like being treated as a child, a primary school kid, in a big open world of serious matters. When, I've seen more from someone claiming that he had a paperclip stolen and they want 2p back through the small claims court. We're about to have all his rights taken away by, the World Health Organization, might be taking his rights away or trying to. Well, that's quite serious. Well, yeah, you'd say, well, what about Keir Starmer? He's a human rights lawyer. Well, what happened to human rights when we're finished? If the World Health Organization locked down the whole country, what use is Keir Starmer, a human rights lawyer, when we've had the rights overriding? He won't be any use to anyone, unless he's trying to get them back, when maybe he should have raised up the 1,700 Act of Settlement in the first place. I've seen the fact that, you could claim someone owes you £10 and, attach more evidence, receipts, videos. You can write more on that than you can write on this when, it's over a matter of £5 or a paperclip, when you're facing we're being treated like idiots by this government. And this is when it comes to, this building and planning objections as well and stuff like that. We actually are being bossed when we're being treated as idiots. This is a problem. And Parliament are getting away with it because they're not being held accountable. There's no consequences unless it's Boris. And in order to get consequences against Boris Johnson, they had to, a lot of media pressure, hell of a lot of complaints, and more for them to even come around and get him in front of a committee. It's not easy. These, the 11 members of the Petition Committee, they're either being deeply misguided, they're deeply uneducated, they don't know law, they don't seem to have an interest in the legal process. I mean, even that Edward Fitzgerald book's left out, the several of the more critical acts, although he did tell me that he had more material that he hadn't yet used it. I was going to put into another book, but those ones are quite important. You would have thought they'd go in the first book. It's just, it's standards. It's not up to, they aren't up to standard. The Petitions Committee isn't up to standard. The government isn't up to standard. And then they're saying that it's us. We don't have any standards. And that is the major insult out of all of it,